are you mostly realtors here, or are you, you're all realtors? Okay, so that's good. 'Cause-
No.
Okay, so
And you
I represent residential landlords and have done so for the last 22 years in Ontario, so I'm here to help you to understand some of the mistakes that realtors are making in regards to their handling of files like this. The biggest mistake I've seen a lot of that's repetitive is realtors thinking that they can assist their client by creating notices to terminate a tenancy. You cannot. In fact, the notice says right on, I'm a legal notice. What that means is that you either have to be the landlord party or you have to have a license by the Law Society of Ontario. If you do this, the notice is automatically defective. And I forwarded 2 decisions this morning so that you could see a most recent board decision dismissing a landlord application because a realtor did it. And the second one is a Court of Appeal decision that gives rise to this whole concept of why you can't do it. So that's a mistake. Stop doing that. Another mistake is that I'm seeing repetitively is a real failure on realtors' part to understand the length of time to get you vacant possession on a tenanted property when you're trying to sell them. And there's a whole plethora of mistakes that are being made in regards to this process. One mistake is that you're not, in your listings, you should be putting in a statement that specifically says, if this is a tenanted property, and if you want vacant possession, then as a condition of your offer, you must agree to provide us with an affidavit that says, I genuinely intend to occupy the unit for a minimum of 1 year. No exception. If you do not have that, do not accept that offer. Because I can't get it for you if they haven't agreed. And I've seen a whole bunch of deals blow up because of that. So let's simplify your lives. Put it in your listing. It's out there for everybody to know. Everybody knows the rules of the game right from word go. The second thing is that in your timing on closings, and this is happening so much, and I'm seeing deals blow up, or I'm seeing the vendors suffer dire consequences, tens of thousands of dollars, by having to change the closing date. So yes, it's a 60-day notice for purchaser's own use. And no, you don't have to compensate the tenant when there's a purchaser. However, if there's more than 3 units, the vendor can't give that notice. Until that purchaser becomes the landlord, then they're not barred by the number of units. But the act, for whatever insanity the Liberal government dreamt up, made it prohibitive. If there's more than 3 units, a purchaser cannot have that notice given on their behalf. They got to become an owner first. So that's something to keep in
Can we
mind.
interrupt for a question?
Sure.
Okay, so you were saying it's a 4 unit, but the buyer's only going to live in 1 unit.
Doesn't matter.
You
You
can give
can't
notice,
give that notice until after he becomes the owner.
but when you become the owner,
They could be 1,000 units, we wouldn't care.
but they can give notice for the others when you all become an owner, even though they have valid leases.
only for the one.
Only for the one.
Only for the one.
Yeah.
But that means that they're assuming the tendencies
Right.
on the others, and lease travels with title, status quo, nothing changes. So that, and I don't see a lot of that, I'll tell you, because why? Because a lot of rents on these properties that are getting sold are below market value. It doesn't make any sense to an investor to want to buy that property and inherit your mistake.
So, but my point is, so you can terminate the other leases once you're the owner? Even though you're not
And well, let's talk about that right there as well. The concept of fixed term tenancies came to an abrupt end in October 2016. It has no meaning in Ontario whatsoever. The Liberal government, with their constant gift giving to tenants, gave them a notice that says that they can walk away from your fixed term with a 27-day notice, and I don't get to ask them any questions about it. So then, in January 2017, a law firm out of London went in front of a deputy judge in Kitchener who is in love with himself. And he posts all of his decisions to Canley because he really is in love with himself. And they were there on what historically we would go after tenants who breached their agreement and leave early and pursue them for vacancy loss. And that's what they were there on. And Winnie dismissed their case. And this law firm is pretty arrogant. They do have a heavy hitter. The lawyer that was on this case was not. And they sent it to divisional court. And sadly, the divisional court upheld the winning decision. The responding result to that is the Liberal government seized the day and amended the legislation on their last round of amendments in September 2017 to make it an offense to pursue any portion of a fixed term at all. Fixed term tenancies were never good for you to begin with because they repressed your rights. People think 2 years, 1 year. No, because your rights are repressed during that time. If that tenant starts paying the rent late, I have to wait till the end of that term. Your circumstances change and you suddenly need to live there. No, until the end of that term. You have to sell. No, till the end of that term. That's what fixed terms were doing to you. Here's the other thing. Fixed term tenancies give tenants a right to assign or sublet the balance of that tenancy. But if you're month to month, that right does not exist. Because there's nothing to assign or sublet. So you now deprive the tenants of that annoying right. I had clients that were back before I really opposed them, would agree to sublet, and at the end of that term would send me to evict. And I would. And I evicted hundreds of tenants for that client. So put fixed terms out of your mind, month to month from the get-go. In Ontario, a tenancy is forever unless you meet the criteria of the legislation. So stop worrying about the tenant security there.
Can I comment quickly? Do you realize that all 50,000 agents GTA all do one year term?
Yeah.
Or longer.
Standard or longer.
Or longer, yeah.
And like, how is this not? How does no one know this?
That's just so they
Oh, no, I knew that.
It's crazy.
I go month to month.
Okay, well you're special.
No, no, I'm not special.
No, no, you.
There's 58,000 agents. We're the exception.
Yeah.
A tenant can leave on 27 days' notice
On a fixed term.
under any circumstances.
No, it's woe is me, my cat's abusing me by looking at me sideways, sir. That's the extent
Then the
that it can
neighbor's
be.
cat looks at
Because I can't even ask them a question about it.
Right.
So be mindful. When I'm a stakeholder, because I'm a long-time practitioner, 22 years in residential tenancy law alone, I get advance notifications of any substantive changes to this legislation so I can be actively on it when it comes into effect. There's nothing I can do about this notice. You know, there's rumor that Ford's going to replace this legislation. That is a lengthy process, probably 2 years minimum before we'll see any changes to the RTA. Minor changes, but no substantial changes. So you're stuck with it. And it was never good for you anyways. And sometimes you would make mistakes and even create tenancies that are 3-year terms. Well, there's case law that says if a lease agreement is 3 or more years, it's invalid unless it's registered on title. And the whole reason for that is discovery. Because let's say you breach your mortgage. Your mortgage says, well, that's enough of that nonsense. I'm taking my toys and going away now. They have a right to discover what you've done. And they can't do that on a fixed term tenancy greater than 3 years unless you've complied with the requirement to register it on title. So, you know, and so they would run into a problem because they would show up and the tenants are not going to cooperate. I don't know who you are, bugger off, you know. And because they send out assessment teams, they're called asset reallocation teams, and they go and they assess what's in there, what are we looking at, where's the rent going right now, and then they issue a direction, tenant, we're now the mortgagee in possession, you must pay us. But you know, I see tenants try to constantly stall that proceedings by saying, no, I got a 5-year lease. Well, then a guy like me is going to show up and say, great, show me that it's registered on title, because if it's not, your lease is invalid, and I am now evicting you on behalf of that mortgage.
So 3 years is max.
No fixer,
no.
month to month.
No, I'm saying
Yeah,
if you're
after-
acting for the tenant, 3 years is max.
Well, 3 years, if it's 3 years or more, it has to be a registered on title to be a valid
So
lease.
2 years then?
2 years and.
If you're representing tenants, I don't represent tenants, I'd rather evict them and crush their dreams every day of the week.
Just a quick question, on a month-to-month, how does the realtor get paid if they do leases?
Well,
It's up to you.
that's your contract.
Right, yeah, yeah.
That's your contract with
No,
your
you
client,
still
your
have work on it.
contract's still gonna say you're gonna get that
Right,
month's
okay,
rent.
okay.
Still have enough.
That's how you're getting your pound flesh. I said I'm gonna hear it come next.
In a lot of provinces, realtors can't do leases.
I'm not even convinced you should be anyways,
Well,
because
yeah,
let's be
I'm
okay with
realistic.
that.
It's a legal contract
Yeah.
that you have inadequate knowledge to know how to
I
do.
totally
Yeah.
agree.
And by the way,
Yeah,
there's a section in the RTA that says anything in a lease agreement that's contrary to me, the law, it's automatically void by virtue of that fact. And when you write, do a little Perry Masonizing, and you create a little clause in there that tells the tenant, oh, we got one here that doesn't have a clue, it broadcasts it to them, and it's automatically void. And you now put yourself in a position of liability to your broker
yeah.
and to yourself. And really, the case law is very explicit. I can hold you 100% accountable for any losses that landlord may suffer, be it rent or damages, because of your failing.
Yeah.
Court of Appeal.
It's like a paralegal trying to.
So
represent
let's just
the-
say you own a residential property,
Right, I hear what you're saying.
and it's owned by a company. And you want a child to move
Can't
in.
do it anymore. The Liberal government, again, in their desperate bid to stay in power, even though Court of Appeal of Ontario said it's okay, for whatever reason, in their infinite lack of wisdom, took it away on their last round of amendments. So yes, you could, because of my colleague Doug Levitt's office, who took it all the way to Court of Appeal, and then they took it away. I don't know why, there's no explanation as to why. We often don't get an explanation, we just get told this is the change. So, you know, it's a real hardship for a lot of people. I just had to tell a client who's been a long-standing client, nope, can't do it. And I had a colleague pull a bit of a fast one. You know, not all of these adjudicators are equal, some of them are stupid. He pulled a fast one and used the Slapsy's Court of Appeal case and convinced him to allow a landlord to do it. Of course, that tenant went to a clinic, of which we're up to our eyebrows, in tenant-oriented clinics. They immediately brought a request for review that was immediately successful because of the amendment.
So could you then, if there was a problem, or if you really wanted to put a child in there, could you
Sell it to-
transfer ownership?
Yeah, you would have to sell it and become a single owner, like as a person named,
Yeah.
and then you could have the rights that you're looking for, to put your own kid in. I actually just did that, and I have a case that's returning next Friday. On
Okay.
that's exactly what we did.
Could you explain what exactly is? I don't know what you're talking about.
So, okay, so if you're a corporation, now a lot of times people, for tax benefits, and it's understandable, you know, taxes are high, they'll put it into a corporate name. It's also for protection purposes, because you're now a corporate entity and you can only sue the corporation. But up until about, I don't know, maybe 6 years ago, as a corporation, the board said no to corporate landlords. And my colleague challenged that, took it all the way to Court of Appeal and was successful. The Court of Appeal said, well, if it's only a small number of directors, that's just somebody trying to get the tax benefit. That's not a real corporation like the giants like Greenland and places like that. So yeah, we're gonna say they can. And that stood for a long time. But the Liberal government took that away. And we don't know why. So right now, if you're a corporation, you cannot occupy your unit or put your kid in. So you're gonna have to transfer it into a private, so what I did with this one, buddies, the family owned this property for a long time under a corporate name. They're old. They wanna get out, they're sick to death, had enough tenants up the year, enough nights, sleepless nights. Son says, okay, I'm gonna help you out, mom and dad, because we can't sell this property because A, the tenants are annoying, B, the rents are way below market value. All right, I'll buy it from him. And thankfully, he had enough common sense to seek my advice beforehand. So we set it up, bought it in his own name, closed the deal. Now I'm evicting that last tenant for his daughter's own use, because we can't.
Oh, I see, put your kid in. Okay.
So that's
But
how
only
that has
because
to
it was
work.
in a corporate name.
If they have a lease in place, you have to wait.
No, we were dealing with month-to-month tenants.
Month to month, okay.
Yeah, leases, that's another reason why leases are annoying, get that fixed end-of-term thing to have to deal with, because it is an end-of-term notice. It no longer says it because it wants to, they act as constantly trying to confuse you. But it is, if you look at it up in the parts of the legislation, it's under the end of term notice section. So, you know, that's where that comes into effect. So let's go back to the original part of that, where we led to this part of the discussion. So you as a realtor, you've got a property, got an active offer to purchase, and now it's time to figure out how to work this closing date. 60-day notice, you think that's plenty of time. You're wrong. Right now, and for the last 2 years, we've been in a real crisis because we have an extreme shortage of bodies to adjudicate these cases, and I mean extreme. Up until just recently, we were short close to 20 adjudicators. We were down to 2/3 of the component. It makes it impossible to get hearings, especially in certain regions. Sure, we've hired a couple more, but the reality is we're going to be 10 shy again very soon, because 3 just quit. Actually 4, because she actually quit a year ago, but they don't take her name off the list because it's just keeping the appearances up. And she works for another board now.
That's the reality,
But they're
folks.
quitting. They're quitting because their terms are all ending as of December 31st. And none of them are willing to take a chance at getting shafted without having a job come December 31st. And there are better jobs out there, because I'll be honest with you, it's a shitty job.
It is.
So we're losing them hand over fist. They're going over the fence like there's no tomorrow. And they're getting better jobs. And they're waving. See ya!
Nobody on
Thanks!
this side.
So it's making it a nightmare. So even though your notice is 60 days, you might not be able to get you a hearing in that time frame. And that's something you gotta keep in your mind with these closing dates. Because I can't get you the vacant possession in time. And I've had half a dozen cases already this year where that's gone that way, and we've had to amend, including one just recently where we amended, waited forever and a day to get a bloody hearing date. We amended based on the hearing date that we were told, July 17th, and then the board screwed me again, and they changed it to August 13th. Now we're not gonna have enough time, because once you get that order and it says the day you can go to the sheriff, now we have to wait for them. And every region's different. In this region, the sheriff is 6 to 8 weeks to come. So now you're really screwed. And you're likely, your client's gonna likely face liability, you're probably gonna face liability, your broker's gonna face liability, and you might even lose the sale. In Toronto, we're running 30 days right now. Other regions like Durham, Newmarket, Hamilton, roughly 2 weeks from the day I can file, roughly. The other thing is, one sec, the other thing is that because their shortage of adjudicators is what it is, their writing time for writing the orders has been dramatically dissipated down to almost nothing. So even though they have a 30-day rule, I have many of them going way past that. Sometimes 45, sometimes 60 or greater days from the day of the hearing to get my order. And I write to them and I beg, can I please have a goddamn order? You're driving me freaking crazy here. And their response is, yada, yada, yada. We'll get to it whenever we can. There's a shortage of adjudicators, have a nice day. And they don't care on how it's affecting you at all. Because the only people who get to go to this board and cry, woe is me and the blues, are tenants. Okay, so you gotta keep these timelines in your mind. You gotta brace your client for it, you gotta structure your deals this way so that you have this ability to adjust the dates in according to the process. Once that notice is served, application gets filed immediately, you sit the waiting period out until it gets a file number and a hearing date. You go there, you make sure everything's in order, your affidavit's in order, purchase and sale agreement's in order, so it's gotta have vacant possession, all your ducks in a row, and then you get it. That's it.
So what time frame should we look at? Seriously?
It's so difficult right now, sir, because I can tell you right now, in Newmarket, for example, well, I have 2 adjudicators from the Toronto North office that drive a car. That's taking a long time to get the hearings in Newmarket, okay? In the Scarborough district, now we're starting to get this fixed a little bit, but up until just recently, we've only had 2 adjudicators trying to cover 5 different hearing locations. And so the time to get you a hearing in any part of the eastern districts, that would be Scarborough, Peterborough, Lindsay, Coburg, Belleville, and Whitby, is very elongated, 3 to 4 months.
If you're representing the
So
seller,
if I've got a seller,
Yeah.
we're selling this property, we've got a tenant, what's the minimum closing we should ever consider at this point? 5 months, 6 months?
4 to 5, 6 months, yeah.
Yeah, so say.
you know
5
what,
months.
what you can do too is, let's say you have a 90-day closing and you're representing the seller, have a clause in there that in the event the seller can't deliver vacant possession, that it is agreed that it will be extended
Sure,
until
but not
such time.
everybody.
Or
Tie the buyer in.
agree that they will assume the tenancy while the process plays itself out.
Right.
Right.
And that you'll initiate the process forthwith without, that's another thing, a common mistake by realtors, and I see this so goddamn often, it drives me crazy. You don't get termination just because you gave a notice.
Right.
It is meaningless, unless you send that to a hearing and get an order by the board that says what day you can go to the sheriff, then you're not getting termination. And I see so many, 2016, I had 6 people in June calling me, Mr. Smith, I'm homeless, what the hell am I supposed to do now? Start the process over. And that's because their realtors believe all they have to do is give the notice.
So would it be wise then to give notice and then seek a hearing? As soon as you give
The
notice?
second the notice is served, file it.
File.
The very second. I do it all the time. On a notice that doesn't have a remedy period, there's no waiting. So I will serve that notice and file it the same day.
Okay, so when each party agrees to end the tenancy by saying an 11,
Okay, so let's talk about the N11 process. Yes, that's a mechanism. If you get them to sign it, file that right away with the L3. Get your order. Because that's what's called an ex-party proceeding, meaning no hearing. Just goes to a duty adjudicator, looks at it and goes, okay, you used my form, you said it's right, you're the landlord, he's the tenant, okay, I get it. But the order says,
Oh.
tenant,
Makes sense.
you have 10 days from the date of this order to file a motion to set aside, and all the little monkeys will. Guaranteed. Because they want to come and cry, woe is me, I need more time because I'm a tenant. So you don't sit on that one. The day you get that one, it goes in. Because it's going to take a week to get your order,
I don't want to know.
and then they're going to have 10 days to file a motion to set aside, and then it's going to be subject to the scheduling. So that's going to be anybody's guess. 6, 7, 8 weeks till they get that motion heard. Most often, I can crush those, but sometimes the board member is going to exercise Section 83 consideration, the reasons to deny or delay, and you're going to be still up at creek. That's why you don't wait. I'll give you a classic example. So last March 28th specifically, I get a call from a frantic landlord that says, on December 23rd, 2016, or 2017, I signed a N11 agreement with my tenant. And it's with a termination date of March 31st. Today, he tells me, fuck off, landlord, I'm not moving. I'm like, well, you turned that into an order, right, man? Well, no, I thought I had to wait till March 3rd. No, crap, you should have filed it on December 23rd.
Yeah, I didn't know that.
Because now he's played you because he's used up all your time.
Yeah. Now he's
So, get it in there today, right now, this second, put everything down, focus, get this goddamn application and get that order. Sure enough, he files his motion to set aside, that little monkey is able to extend that to July 31st.
Yep. Yeah, he knows it. He knows
They
it.
all know how to game the system, people. The Liberal government spent a lot of time and money educating them how to game the system.
And he doesn't pay rent in the meantime, just.
Well, then I just bring an application for arrears only because I don't need termination, I already got it.
Express.
You know, that's how you treat them with that. So, and I'm less than kind on that, but make me live your miserable life twice. Yeah, I'm not exactly nice.
So if he's not paying,
I file an L9 for arrears only. I don't need termination, I don't have to give them a notice. I already have termination off my N11.
so they still have to end up paying.
Yeah, so you have to pay for as long as you're in there.
Sorry, Steve, could you just describe the process from start to finish with these notices and?
Hang on, I promised her I'd come back to her.
This might help, because I don't do a lot of rentals, almost nil.
Right,
I have a client who wants to sell a property that's on Lake Ontario. The house is a shack, there is a tenant in it, but it's not really livable, although someone lives there. The lady's 6 months pregnant, doesn't want to move, we want to sell the property.
what do we do?
Well, in situations like that, I'd still follow the process. She obviously is not gonna sign an N11 agreement. You can usually tell, if the rent's below market value, not gonna happen. Can't buy them out, all right? I've tried.
Yeah,
So in that situation, find your purchaser that's willing to do, and I just actually pulled this exact stunt on a tenant up in Severn area. So the tenant had some lightweight paralegal from Aurelia write my client all these nasty letters last August. Oh, the property's in disrepair, fix it, fix it, fix it. We're talking about a 70-year-old cottage, for Christ's sakes. Of course it's in disrepair.
well, this one is gonna be bulldozed.
Of course. Well then, and that might even be the better approach as well, to the demolition and getting them out that way. Instead of having to wait for a seller, demolish it and sell a vacant lot, probably sell quicker. Somebody else is gonna have to do that, right?
Yeah,
Sure.
absolutely.
So on my situation, we initiated demolition. My client's applied for the permits. But he says, hold off on filing the application, Stephen. Something's come up and I might have another way. Sure enough, a family member came, like a friend of the family came and said, look, you know, childhood memories here. I don't want you to demolish it. I'll buy it for you. I can fix it myself. And so, where the tenants have a right under Section 83, if you're in substantial breach of any standard, municipal standard, or anything coming out of your lease agreement, the act actually says the board shall deny. Save it, except I have a case decision that says differently. So if the termination is going to cure the breach, demolition, or somebody else has become a non-tenanted property, then the case law says, no, the board shall not apply Section 83, and they should grant the termination. And the funny thing about it is it's actually case law against the Ontario government.